But in our own thinking, what is case management that we are talking about? Lord Justice Wolfe in 1996 gave a report on case management, and he set out various things which are today working in England exceptionally well. Okay? So that is what practitioners and judges becoming better at what they do. That is, they do the same thing with less resources and in less time. So the work is the same. It is only how you do it that makes it different. So that is the Lord Wolfe report. And that is for these three things: improving efficiency, reducing delays, and cutting costs. And what I would urge you is that when you are thinking and when you are coming together and you are innovating, please innovate ways in which these three things could be achieved, because then you will have really done something for your profession. So the ambit of case management, the management in our system, is two: procedural and substantive. Substantive, of course, requires various laws, and we are very good in that. We deal with the laws, the judgments, and all very well. But the procedural aspect is what we lack, as I told you. And that requires infrastructure, which costs a lot of money. So we depend on technology, and we depend on the government and e-courts and all of those things. But sensitivity is what we have in us. And that doesn't cost anything. It only requires some empathy and some sensitivity. I would call it sentipathy. So therefore, there are various stages for a litigation lawyer. All of these we need not go into. In each of these, you can have, for example, the simplification of procedure. You can have, for example, the non-value-added items which we throw away, and you go to the main item, etc. And you do all of these things right up to the ADR, etc., which is a part of this case management. Okay? I don't want to go into each of these, but I may tell you that things like summary judgments, for example, are judgments on arguments. They are, for example, very important in America, and 90% of the cases don't go to trial. They go on arguments. But here, our lawyers in arbitration as well as in adjudication don't understand that it is so much better to get all the documents together, the contract, the emails, the registers, whatever that is, and ultimately argue, because documentary evidence will always prevail over oral evidence. Okay? And so often we find a lot of oral evidence led, and we can take out about 4 sentences from there, which may be useful. Now, this is a great loss of time, and that is bad work. Okay? So there are all of these things. Oral applications, for example. So many applications can be just done orally. Yesterday in my arbitration, somebody tells me that, okay, we are deciding now we will not have any further evidence, so we will put in a joint persis that we will go on with oral evidence. I said, there is no need. I'll take down your statement just now only. You want to lead? Okay, I'm keeping it for arguments. Finished. There was no need for any application, oral or in writing. But so many of you, please think, you will be making so many unnecessary written applications, and I would urge you, henceforth, don't. Okay? So costs, of course. Costs are, of course, dependent on the judges, and real compensatory costs, because it must compensate the party who has been aggrieved by all these wrong procedures. ADR is a completely separate thing, and so are the summary suits. All of these things go together. So now we have to remove the roadblocks. When we are thinking about how we are going to have an overall impression, we remove the roadblocks. Pleadings as evidence. In our arbitrations, we now tell them that these pleadings I will accept as your evidence. If somebody wants to cross-examine you, they can cross-examine. Please don't repeat. But of course, if you have anything else to say, by all means say, because that can come. So if suppose there is a private document and has to be proved by somebody, that evidence will have to come, because only the author can prove a document. So otherwise, we take pleadings as evidence, which can be done even in adjudication, actually. Because in Bombay especially, pleadings consist of submissions, judgments, law, and everything that pleadings should not be. It should be under the CPC, brief, concise, and precise. And it is anything but that. Okay? Now, when it is anything but that, and your evidence is also right inside the pleadings, which should not have been, then there is no need to repeat at least. If, of course, your evidence is not in the pleadings, you lead that evidence. Suppose you say in your pleadings of a 3-page plaint that there was an oral agreement to sell this flat. Then in the evidence, you have to set out where the oral agreement took place, how it took place, etc. This is not pleadings, but we find it in pleadings. And we say now, no more repetition. Then evidence of all witnesses together is now a part of the statute under the Commercial Courts Act. Okay? So we have in our arbitrations also that if you are going to examine 7 witnesses, we are not saying no, get all the evidences together. And you as lawyers, when you are going into adjudication or arbitration, when you are sitting down with your client, you must always find out how many people will give evidence. What will be that evidence at one sitting? And you please remember that that will be the best thing that you can give your client. Formerly in olden times, and not very olden times, I'm not talking about the prehistoric times. It is the times when I started my practice in about 1976. I used to find briefs in my father's office of advice on evidence. I don't see that anymore at all. Now, this advice on evidence is when the pleadings are filed, you discuss with the counsel, you discuss with your client, get all the documentary evidence, the oral evidence, consider everything, and give your actual note or advice on the evidence you are ultimately going to lead. At that time, suits may be reaching in some months. Then they were reaching in 2-3 years. Now they are reaching after 23 years. Okay? You are going to forget what your client has said. Your client may die and the son may come. And I don't know about you and I. But nevertheless, it is always good then to have all the evidence of all the witnesses collected by lawyers at the same time. Don't say, today I'm tired, now then nothing else. Go about, do 5 other matters, you'll forget this client. And that is not service. It is actually disservice. Then there is simplification of proof of documents. That is very essential. Now, all the old, seemingly genuine documents we take on record, not only in arbitration, but also in adjudication. If suppose there is a salary certificate, for example, that comes, we tell them that you give me the salary certificate of the whole year. Now, if one can be forged, everything cannot be forged. If there are rent receipts or electricity bills, we call for all of them together. And then the real genuine things can be seen. And then documents in a group. When there are documents of matters in a group, take them together. Consider them together. It's a very sound practice. Now, amendment of statutes, of course, is not in your domain. These are the statutes and these are the sections which really require amendment. They require to go out of the statute book. But that's a part. And the updation of court fees also is a matter for the government, not for you, but it helps. So I would say, for people like you, if it is to be, it is up to me. And if each one of us does the same thing differently and better, we will have a very good justice system. Thank you.